Hey, I'm Kelly Bennett, and we're here to answer some more questions that you've got regarding family law and family law mediation. So today's question is from Jeremy, and Jeremy asks, hey Kelly, I filed for divorce 2 months ago, and I understand that in 6 months I should be divorced. Is that true? Well, kind of, Jeremy. Let's get some clarification. And this is a question we hear a lot in divorce mediation. So there's this family code section 2339. And what that says is that the earliest date that the court can terminate your marital status is 6 months after the court obtains jurisdiction over the other party. So what does that mean? Well, Jeremy, if you filed for divorce 2 months ago and you haven't served the papers on your wife or had them served on your wife, then the 6 months doesn't start to run. It starts to run the moment she gets served with the papers. That's the earliest. So we go about 181 days as the earliest date from the date the other party is served with the divorce papers to the earliest date that the court can say your marital status is terminated, the marriage is over. Now, the second part to that question is what you're really asking is it automatic? It's not automatic. And here's where people really get messed up with the 6-month rule. Let's say you come into mediation. You filed for divorce 2 months ago. The wife is served. We're all at the mediation table. And I finish up your settlement agreement. What we're going to put in the settlement agreement is the date marital status terminates, you're divorced, is going to be the 181 days from the date your wife was served to that 6-month date. And that will be the date. Now, I'm putting it in a settlement agreement, and with that settlement agreement, when we're finished, we submit the entire judgment package, which is a form to the court, and that's what the judge signs off. So we're asking the court to go ahead and enter your settlement agreement as the court's orders, including that date that's prospective in the future, the 181 days, right? We're asking the court to say, okay, as of that date, the marriage is over, and all the other agreements, by the way, that we've made in the settlement agreement are actually orders of the court the moment the judge signs the orders. So in that scenario, we're asking the court, go ahead and terminate marital status. We're in agreement. Now, let's say you weren't in the mediation setting. The only other way you get marital status terminated, other than asking the court to do it in advance, either by a settlement agreement or by a motion asking the court, okay? The only other way you do it is at trial. And that's if you don't settle your case, you let a government judge decide on all of your personal issues, which of course we don't recommend you do because you don't have as much control, but you get to trial and the judge makes all those decisions and at trial ends the marriage and declares marital status terminated. But the earliest date that can appear on that judgment is 6 months from the date your other spouse or your spouse is served. So Jeremy, thanks for the question. I hope that helps you, and we'll see you next time.